Good afternoon. Welcome to the Theory and Practice of Regulation, the first course of the Regulatory Training Initiative. I'm Carl Peckman. It's my pleasure to welcome those of you back who've been joining us over the past several weeks, and to welcome those of you who are new to this class. The classes are now being posted on the NRRI YouTube site, which we will share information on that at the end of this lecture. We're very pleased today to have Diane Munns join us to talk about the practice of regulation. Last week, Chairman Phillips from the Washington, D.C. Public Service Commission talked about the products of regulation, talked about rate making, talked about how utility commissions make decisions about what utilities can and ought to be doing in terms of the way that they provide and the types of service they provide to customers. The practice of regulation is how we get that done. And Diane Munns is an expert at this. She started her career as an attorney at the Iowa Utility Board. She then was promoted to become a commissioner of the board, after or during which she served as the president of the National Association of Regulatory Utility Commissioners. Subsequent to that, she worked with the Edison Electric Institute and has also worked with the Environmental Defense Fund. So she has a very diverse background with respect to regulation, both as a regulator, as someone concerned about utility interests and environmental interests. Today, we're going to have a somewhat different format. We're going to follow a Q&A format where I'm going to ask Diane questions, and towards the end of the session, we're going to open up the dialogue to your questions. So it's a pleasure to have you, Diane, and let me start by asking, what are some of the ways in which commissions differ? And does the way that commissions differ in terms of whether they're elected or not elected affect the processes that occur at various public utility commissions?
Thank you, Carl, and it's a pleasure to be here today. You know, I didn't realize till I got to NRRI that every commission didn't operate the way that mine did. So I'll start by the name. Mine was called a board. Some are called corporation commissions. They're called commerce commissions. So there's a variety of names. They differ in the number of commissioners they have. Most of them have 3, but they go all the way up to 7 commissioners. Some commissioners, most are full-time, but there are a couple states that have part-time commissioners. And then, of course, about half the states are appointed, the other half are elected. Those that are appointed have differing ways in the way they are appointed, some of the requirements, what they regulate differs from state to state. But when it really comes down to it, everybody has the same function, which is to regulate rates and services and safety and do it in the public interest.
Terrific. Now, having served both as staff and as a commissioner, in terms of the overall process, how do you see those two roles? How do they differ? And what different types of roles will staff play at a commission?
Well, I consider the staff to be the real engine of the commission. Commissioners come and go. Staff is usually there. Some of them have careers there. They have the technical expertise in finance, in economics, in accounting, in law, and in engineering that are required to evaluate evidence and cases that come before the commission. So the staff really looks and evaluates based on the law, based on the facts, and presents to the commissioners, here are the range of things that you could do that would be lawful and reasonable. And then the commission takes it from there and does their function, which is to apply their judgment for which they were appointed to the commission and use their discretion to come up with final decisions on how things should be done.
And when you talk about things being lawful, what's the basis for determining what's lawful? Where do the commissions derive their authority from?
Yeah, so, you know, some of it's constitutional. That's U.S. Constitution, their Constitution, on things like due process, on things like confiscation of property. Most of it is in the agency's enabling statute. And I tell people, become very familiar with your enabling statute. That comes from the legislature and really outlines what you can and cannot do. There are also other constraints in administrative law, and usually that's a general chapter, but that outlines how you go about doing things, in addition to what's in your enabling statute. And finally, there are what I call the fairness statutes, and those are things like your open meetings statute, your open records statute, your ex parte requirements that really protect the integrity of the agency. All of those are both give you authority to go forward, but are also constraints on your authority on how you do things and what you can do.
Well, thank you for that explanation. Let's go to the nuts and bolts of how commissions operate. First, in addition to the constraints on their authority, there are usually some ground rules in how they operate. Is that correct?
Yes, yes.
And so the fairness statutes would be part of that, I presume.
Yes, they are. And really everything that is done there really stems from due process, giving the parties and those who appear before the commission the opportunity to state their case and to do so in a fair and open way. Transparency is important.
So when I first started at the New York Commission, we handled most rate issues or all rate issues in litigated proceedings. They were called adversarial proceedings. And over time, we became more collaborative in terms of having conversations, mediated or negotiated settlements. How does due process fit into those? Is there also due process in terms of the collaborative process?
I think so. You know, commissions have been, I think, more so lately with changes in technology, really doing more kinds of collaborative, open proceedings. But I think the same thing applies as who's in the room. Is everybody welcome in the room? But if a commission is going to take final action on something, they have to do it in one of two ways. They do have to have an evidentiary proceeding. And either that or they have to go the rulemaking route and in order to take action. So those collaborative proceedings, those investigatory proceedings, I think are very, very important, but you still need those more formal proceedings in order to take final action.
So one of the major products that regulatory commissions oversee are rates and how utilities can charge and how much they can charge. What's the general process by which a rate case comes before a commission?
Well, a case is one of those evidentiary proceedings, and it comes before a commission by a party, usually a company, filing with the commission asking for an increase in rate. So it's usually the company, although in my state, and I don't know if this is universal, but the consumer advocate could also bring a case asking for rates to be lowered. But let's just stick to the more common rate case that people know, and that is a company comes forward and says that either their operating expenses have increased, or maybe they put a new plant into service, their rate base has increased, or maybe the cost of money has changed and they want an increase in their return. So they will put together a case with testimony and make a filing. That filing comes to the commission. Then the process begins. There will be others who take a look at that. Maybe your state consumer advocate, maybe your attorney general. You may have other interveners like large industrial users or environmental groups, and they also will file testimony. Following that, there will be a hearing where the commissioners or their administrative law judge sit as the presider, and there will be cross-examination on that testimony. Then the staff job begins, and we'll talk about the staff more. But the staff, which is an expert staff, evaluates the testimony and puts the case together for the commission to decide. They will look at the law, the lawyers will look at the law, the technical staff, the finance people, the economists will look at the return. The engineers may look at the new plant that's been put into service. They will each approach it from their expertise and make a recommendation to the commission as to what the rates should be. It is a recommendation. Then the commissioners will exercise their judgment and issue a decision and set the rates for the company.
And I think that after they do that, of course, there's one more step that you've spent a fair amount of time with, which is the post-decision litigation in terms of the challenges to the orders. Do you want to just touch on that a bit?
Yeah. When they issue their decision, it will be in writing, and it will contain findings of fact and conclusions of law, so that people can understand what was the basis for the decision. If any of the parties to the case disagree with the decision, they can appeal it to the court. Now, what the court does is not have a new hearing. That hearing took place at the commission. They will do their review based on the record that was made at the commission. They won't substitute their judgment for the judgment of the commission, but they will look at things like, did you stay within your authority? So was the decision legal? Is there substantial evidence to support the decision that was made? So they'll look at the order, they'll look at the transcript from the hearing, and they'll say, was there evidence to support it? Was it reasonable, what the commission did? And then if on those points there's been an error made, the court doesn't make a new decision. They turn around, they send it back to the commission and say, do it again.
Yes, and if I think you might agree that the two words that the commission never wants to hear from the court are that the decisions were arbitrary and capricious.
Arbitrary and capricious, yeah. Yeah, and that means just what it said, that a decision was made without reference to law or to the facts of the case.
Well, let's just focus a little bit more on the record. And as a former staff member myself, we always found it important to create a record that supported a variety. We were not necessarily taking positions, but our job was to really create a record upon which the commission can make a reasoned decision. But stakeholders and the utility also participate in the record. So can you talk a little bit about their role as well?
Well, as I said, in a quasi-judicial proceeding, they will present testimony. When that case comes in, they'll put their experts forward to talk about different points that they may want to make. Again, they'll probably put a rate of return expert on to talk about what they think their return should be. Consumer advocate will put a different one on. So they have the responsibility to make the record and to show that the increase that they are seeking is justified.
And the record, just again, is a quasi-judicial record, or in which it's a very formal process,
Yes.
typically. Now, over the years, though, there's also been a move towards mediated settlements of rate cases. How does that process differ from the process of litigated? And when we talk about litigated, the other word that we use for litigated is adversarial process.
Or contested.
Or contested.
Yeah, and you have, when the issues are contested, the issue is wide open for the commission to make a decision. You may get something that's mediated, you may get a settlement where the parties have come together and come back to the commission and say, we have agreed, here's what the decision should be. It doesn't absolve the commission of responsibility. The commission still needs to look at that settlement and determine that it is reasonable and in the public interest. It's much easier to do when all the parties join the settlement. You may get some parties, you may have a partial settlement. It can get messy. But as I said, the commission retains responsibility and authority to make sure that the conclusions reached are in the public interest.
And just one other thing on settlements, that when a settlement comes in, the commission evaluates it, and oftentimes there's testimony involved in supporting a settlement as well. So that,
right, to demonstrate that it's reasonable.
Now,
and how it's reasonable.
I think it differs by state, but in Iowa, do the commissioners sit and hear cases? I know, for example, in North Carolina, they do. In New York, they would only on occasion. So, and in California, I believe they do. So how is it in Iowa?
In Iowa, there was one administrative law judge, and that person usually did a lot of the siting issues for transmission lines and those kinds of things, but always on rate cases, the commission in Iowa sat on those cases. In other states where they have more staff, they may have more administrative law judges, they may frankly have work. Administrative law judges sit in those hearings and receive the testimony and preside over the hearing. They'll then come up with what's called a proposed decision, and that will be sent to the commission so that the commission makes the final decision. They may agree with what the administrative law judge did, or they may change it. It's not binding on them to accept or adopt, but if they are going to change it, it still needs to be legal, and it still needs to be supported by substantial evidence in the record.
So we just received a question that I think goes to this this notion of a recommended decision, and I think this will help clarify, or your response to this will help clarify. And the question is the staff reports of the commission generally made available to the parties or interveners for comment before the commission makes its final decision? And I think what we're really talking about in the terms of the staff report is what you're talking about as a recommended decision.
I'm not sure that it is. Of course, a proposed decision would be made public, and then the parties would be given an opportunity to comment on it before it goes to the commission. There is oftentimes at commissions a staff report that is an internal memo that puts the case together for the commission. When I was a commissioner, that was not a public document. I think it was called the gold memo. It came from staff to them. I think it now is a public document. So I think that varies state to state as to whether or not they make that public. What I can say is when the staff does a memo and really puts the case together for the commission, talking about the law, talking about the evidence, and making recommendations on where they see the decision going, or the range of options that the commission would have. The evidence at that point is in the can, and you're not going to reopen at that time to take new evidence. The commission is going to go ahead and make a decision. Once the commission makes a decision, often under administrative rules, there is an opportunity for rehearing, and for the company or any of the parties to say, no, I don't think you quite got it right, so take another look at it. So they would have an opportunity at that point to make their arguments, and if there was error, to get it cured at that point before it goes to court.
Okay. Well, we've been focusing, at least initially, on rate case and rate case process, but
yeah,
while that may be the most visible form of regulatory activity and have the, a very significant economic impact, there are many other areas in regulation, and there are many sort of surprising areas in regulation that different commissions have. I know, for example, in Hawaii, they regulate intra-island shipping. In Rhode Island, they regulate the ferries to Block Island, and I have, as the head of NRRI, been proposing to do a study on the ferries in Block Island unsuccessfully. And when we were talking earlier, I was surprised to hear the example of regulation that was a bit of a surprise to me in Iowa. It has moved on to a different regulatory authority. Why don't you let us know about that?
Grain warehouses. So the big bins that stored grain, they stored grain for a lot of different people. So you had to make sure that all of the rules and the bonding and the safety and all those things were in place. As I said, that's moved on now to the Department of Agriculture that I think is a more appropriate place. But I'll give you another example. I know in Pennsylvania, a couple of years ago, they had a lot of issue with Uber and whether Uber was a public carrier, whether they should be allowed to provide service, whether they were a regulated entity. I have a friend there, and she talked quite a bit about that. Other states, didn't have that authority and stayed away from it. But in Pennsylvania, they were knee deep with Uber.
And often, it used to be trucking was often regulated by different utility commissions, and then that frequently got spun off to transportation and things of that sort. But at the core, I mean, going back to Munn versus Illinois, in grain elevators, they were all affected with a public interest.
Mm-hmm.
So, but there are other activities that are affected with a public interest that commissions are involved in, environmental, for example. And one of the main environmental impacts that we have from utility service that I believe is regulated by some commissions in the country is with respect to siting. And what's interesting in a sense about this is that brings a whole other set of skills to the commission. What's the experience in Iowa with respect to, what role did the commission play with respect to siting and the staff in those proceedings?
Commission did citing. It was more on the need side, like discussing and making the showing that there was a need for new generation as opposed to the environmental regulations. So that was the regulation that was done by in Iowa. I think a lot of times we see the of environmental regulation, which is the expenses that are associated with it flowing through and into rates. Years ago in Iowa, we did the cleanup of manufactured gas sites. And that regulation, we made the decision that it was appropriate to clean those sites up, and the cost of cleanup for those sites was flowed through to customers.
Very interesting. So you actually made the environmental determination to clean up the sites as the commission.
We made the decision to pay for it, which I guess is about the same decision as making the decision to clean it up.
Well, in the overall process, we have a question. As a commissioner in the process of regulation, how important is it to get consensus between the various commissioners?
As I said, it's a process that is fact-based. So I think a lot of times there is less contention than you would think because the facts take you to a conclusion. I don't know that you have consensus. I think that we're going to have different points of view. We didn't talk about the appointment process, but in a lot of states it's done by the governor. And as the terms are necessarily staggered, so you will have carryover maybe from a previous administration. Some of the commissions are required to be balanced between Republican and Democrat. So you may have a different philosophy towards things. I think one of the things that surprises new commissioners is that most decisions are not made on the basis of whether you're Republican or Democrat. And that really doesn't come up very often at all. It's a weighing of the evidence. And I think that dissension, happens a lot less than you'd think. I don't think it's necessary, because I think there can be healthy differences of opinion, because commissioners are exercising judgment and they're given discretion.
Good. Well, I just got a question that from the group today, that it seems that of the various parties in the process, that consumer advocates play a particularly unique role. Can you talk to the role of the consumer advocate in the process of regulation?
Yeah, and like I said, a lot of states have consumer advocates. When I started, our state did not have a consumer advocate's office, and the staff presented the case, and it really put them in a conflict situation. So they changed the law and created an office. The consumer advocate is just that. It is a group of people who are to bring forth the perspective of the consumer and argue for the consumer in the cases before the commission. I do want to say that the role of the commission is not a consumer advocate role. They are there to balance the interests of the company and the interests of the ratepayer, of the customers. I think sometimes there's some confusion about that, and people will speak of the consumer advocate role where it really is not the responsibility of the commission to advocate for the consumer. You want to make sure that point of view is heard in the case, and you want to make very sure that people have an opportunity to get that into the record. But your responsibility goes both ways, to make sure that the company has adequate funding in order to do what they need to do, and that customers are protected in the process.
Right. Well, that's very helpful, I think. And I'm sorry, I just got another note that my voice was fading, and I've generally not generally not accused of having a fading voice. So my apologies to the folks out there. I'll try to speak up. But we talked about consumer protection a little bit just now, and the commissions typically have a role in terms of customer protection with respect to customer complaints and things of that sort. And that's a whole different part of commissions typically. What's your experience with that, and how they, the role that they play within commissions?
Yeah, we have a consumer part of the commission when individuals have a complaint, and often it's not a complaint, it's a misunderstanding about their bill, or there might be some confusion. It's people who can explain to them either about individual things, if they're concerned that their bill is too high. It may lead to questions about, is it a metering issue? So I think a lot of times they're a really good education point, but they're also a really good place. They're almost like the canary in the mine, in that if something is wrong out there, start hearing from people, and your customer service will hear about it. Years ago, when after the breakup of Ma Bell, there were some issues in the Midwest with one of the companies. They had made some changes to their customer service, and people couldn't get through. And we very quickly heard about that through customer service and people issuing or calling with complaints about that. So you really need to listen to people and take a look at what kind of complaints you're getting. It will really give you information about the companies that you're regulating.
Well, you mentioned the breakup of Ma Bell, and I know that you played a significant role at the Utilities Board in that process, and so this is a process. And by the way, next week we're going to have Sudeen Kelly, former chair of the New Mexico Commission and former FERC commissioner, talking about the state federal jurisdictional issues. But from the standpoint of a staff member, which was your role at that point, when you have these state federal issues, what role did you play with respect to the representation of the Iowa Utility Board?
Well, I could do an entire hour on that case. That was a case after the '96 Act that opened up local markets to competition. There was an issue in that case as to who took the lead in setting rates, whether it was the federal government or whether states had more leeway to do it. Our state decided to appeal the rules. There were about 600 pages of rules that the FCC came out with. We decided to appeal that. It went to federal court. We had the rules stayed. It ended up going to the US Supreme Court. I argued it for the states and had 30 of the states who were also parties to the case. I would encourage people, if you want to see complex litigation, take a look at that case. Up the first 30 pages are party. It was a really exciting time. And I will tell you, we did lose that jurisdictional issue by a vote in the US Supreme Court.
Well, and I think those involved in the electric industry won't be surprised, especially after they hear the lecture next week, that there are many jurisdictional issues that will affect the scope of regulation at the states. So we won't drop the jurisdictional issue, but we'll move on back into the regulatory body, and in particular, one of the things that a regulator does, or a state regulator does, is assure standards and both safety standards and so what's, as a commissioner chair, what kind of staff did you have and what kind of processes did you have for evaluating safety and things of that sort, and the scope of what you looked at?
Yeah, you know, there are a lot of things within the commission, a lot of filings made. There's a lot of compliance filings. There's a lot of informational filings. Things like, for example, with respect to natural gas, are they doing the testing that needs to be done? Are they doing it at the intervals that it needs to be done? What are the results of those things? That information is coming into the commission, and staff is looking at it. You can do, first of all, make sure that you are in compliance, and compliance is, a lot of those things are set out in your rules. Or with respect to natural gas, you are doing a lot of the safety inspections on in partnership with the federal government and their standards. So a lot of that is day-to-day work. You need to make sure they're in compliance, but a lot of that information can also be used for trending and you can again see what's going on with your use. But yeah, there's a lot of information that is collected by the regulatory commissions outside of rate cases or contested cases.
So going back, I think, more into the rate case realm, there's a question of, do issues of equity generally fall under the larger category of public interest? So is equity an issue that you see in public interest, is somehow, or is that involved in the weighing that you have between the company and customers? And I presume the weighing is also more complex now. Equities with other stakeholders, how do they fit in?
Yeah, I agree. I do think it's part of the public interest. As I said, after the staff takes it, your expert staff takes a case, and they are the engine for you and gives it to the commission. That's when you exercise your judgment and you try to figure out, you know, within the range of what staff has told you is legal and supported by the evidence, what you think can be tolerated, or how fast do you want to do it. You know, that's where things like rate shock come in, and your judgment and equity kinds of issues. I do think that's part of the public interest, and that is part of judgment that is exercised by the commission on the facts.
So I've been asked to clean up one term that we've been using, or two terms that we've been using, and I think that you'll agree with me that they've changed over time, our reliance on one versus the other, and that's ratepayer versus customer. So yeah. I agree. I think now we prefer to call them customers, but for most of my career, we referred to them as ratepayers. And I wish that I could clear that up. I think that we more universally like to refer to them as customers these days. I've had
Maybe
the same,
you have some thought, Carl.
No, I've had the same experience, and of course, customers are now being called prosumers, customers who participate in the operation of electric systems, as opposed to just being passive customers that take service from the electric system. So the terminology continues to evolve, which is one of the reasons why regulation is so exciting, because as you know, and as we both experienced through our careers, things have changed dramatically. And it's what I call endlessly fascinating. So, but talking about things that are fascinating and really exciting, how do commissions think about new issues, for example, you know, I think we both probably experienced the regulatory processes for inclusion of what initially was called demand side management and then became conservation and things of that sort. And it was a long process of change, but it was significant and has resulted and change seems to be accelerating. So what's the sense that you have in terms of the commission role in directing or receiving, and in particular, what's the role of staff, and how can staff feel engaged in that process?
Yeah, I agree. I think that one thing that's different now than when I started my career is that there are a lot more players, then a lot more parties and a lot more interests that appear before the commission in a case. Things are more complicated than they were there for a while. I think it's the role of staff when a novel issue comes in to understand the technology. And you may want to, if you know that it's going to end up being an issue, undertake some informal processes to educate people. For example, I'm a big proponent of site visits so that people can actually see technology and see how it works. I think that it's a really bad place to educate the commission and the staff during a hearing, because cross-examination is so constrained in what you can learn from it. So I think when something new comes, that it really is incumbent on the staff to understand it, to get it before the commission in a way that's legal. And I think not just the commission, I think that it's all players, the consumer advocates, the environmentalists, you know, whoever, the public at large, who, if they want to be educated on a new issue and the underlying technology and what's happening that is causing it. And as I said, I think doing it informally. Now, you can't take action informally. It will usually end up in a case, maybe a case with a specific party. It may be a rulemaking that you're doing to take action. The other thing that I really recommend people do is look to see what other states have done, because these things often happen at different paces across the country. For example, I think the adoption of solar was faster in a lot of places. So look and see what their experience has done. The states are laboratories. And you can really benefit from good thinking elsewhere on these topics. And I always am an advocate for NARUC and for NRRI and for the good work that you all do in educating commissions on these new and novel issues.
Well, thank you for that. And just as an aside, if staff members are out there are interested in particular issues and writing papers with us or for us, we're happy to work with you. We think it's important, as you're saying, that staff look outside of the borders of their own states. But in a sense, you've also touched on here the notion of a stakeholder process, which is broader than just a litigated process, where information could be shared, and one can either try to educate or build consensus around certain issues. They can be fairly narrow. I remember in New York we had a process on alternative methods of transmission costing. It was not a hugely well attended process. It was very dry and technical, but important. And then there are other processes, for example, like environmental and energy efficiency, that were much more well attended. So, how do you see staff's role in those stakeholder processes, and do you have recommendations for them with respect to preparation or learning or give and take and things of that sort?
Yeah, I do. I think that staff has a primary role on that, to get it organized in a way that's fair to everyone. We didn't talk about, and I want to touch on briefly, there are a number of statutes in every state that have to do with open meetings, with open records, with ex parte communication. These fairness statutes that deal with due process are something that we really need to take seriously. And if we have new staff commissioners, very, very important, because they are the basis for people having confidence in the processes that you you undertake. So I think that the staff has a big role in these kind of informal proceedings, to get them organized, to attend, to understand, and to get them to speed so that they can take a lot of things that are very technical and get ready to explain to commissioners who oftentimes are not technical people. So doing that translation so it makes sense.
Well, I think that's right.
It's a
From
big
my
role.
experience, that it's very important to communicate, and that often the ability to communicate is just as important as your technical expertise.
Yes, absolutely. Absolutely. Yeah, I couldn't agree with you more. You may be an engineer or a lawyer or an accountant. Think about how you are doing things. And you really be able to, I don't know how to put it except a translation. And if you are going to write up a decision, it's going to go to court, and the court is going to need to understand what you did. So to explain that, as I said, makes sense.
So the next question may push our boundaries a little bit in terms of process today, but I think it's an interesting one. It sort of brings us back to Market Street Railroad, which is in the role of balancing interests between the company and the customer. At what point does a commission allow a company to fail? And I would add to that question, and what happens to the role of the regulator once a company fails and goes bankrupt?
Yeah, those are really hard questions, because I think you have a responsibility to make sure that they're given an opportunity to earn, but you're not required to do a guarantee. So I think sometimes, I know that when we did decisions, we were always very careful to think, what are we messaging to Wall Street? What are we messaging to the money people about this? But it's not your responsibility to manage the company. The management of the company is done by the company. I have overseen cases where companies did fail and they ended up being put up for sale, and others coming in and taking over. So this is my opinion. You don't need to be bailing out people. I did have a case, I remember particularly, one company had acquired another one. This is years ago in a phone company. And we had looked at the evidence, and it appeared to us that they wouldn't be able to make it. And they gave us assurance, their expert gave assurance that they could. So that's what we had on the record, and we approved it. Well, it soon became clear that they were not going to be able to raise the money that was necessary to do what they needed to do at the company. They tried a legislative fix. They came back to us again, and no, it ended up going to court. And we ended up in settlement allowing them to raise rates, but requiring them and overseeing that all of the money from the increased rates went back into service and increased service and capital, because they had been, their equipment had not been upgraded, upgrading equipment that ultimately made the company successful. So that's kind of a long-winded answer. I'm not sure. But I don't, it's your responsibility to prop up management that isn't doing what they need to do.
And one of the tests that we use with respect to the ability of utilities to recover funds is the prudence test. And could you just give us a brief overview of that and how staff and other parties play in to the evaluation of what a prudent decision is and the role of a prudent decision?
Yeah, a prudent decision means that you have good management, that people are using good decision making, that they have followed due diligence and asked the questions that need to be asked when they have made decisions. I mean, sometimes you can do all those things and, you know, go somewhere that isn't your fault. But sometimes too, that there are things that are done that are not prudent. I remember a nuclear case we had, and they had things had gotten messed up, and they ended up putting concrete in where the turbine was supposed to be. They got wires crossed, so they had to break concrete out in order to put the turbine in. And they wanted to pass those costs along. And that was not prudent management of the project. You know, so you have to be able to look at that and say, if you've done your job the way that you should have, what would the result have been? And as I said, we can't anticipate everything, but if you had followed good management, what would have happened?
So in a case like that, you would, the kinds of staff that you would have staffing a case would be accountants, engineers, attorneys,
economists, finance people. Yeah.
So the finance people would potentially maybe look at the effect of a disallowance on the utilities cost of money so that you could balance how much you wanted to disallow.
Yes. Yeah. They would give us that range, or maybe you would disallow an entire expense. I mean, you have different options for how to deal with things.
Okay, well, the next question I think is a fascinating one, and one that I had wished that I had asked somebody earlier in my career when it was potentially still an option, which is, could you offer some practical advice on what, oh my goodness, it's moved around on me. It's disappeared, but okay, can you offer practical advice for current staff members, mid-career, early career, on how they can position themselves or what steps they could take to become a commissioner?
Sure.
And we're talking about probably states with appointed commissioners at this point, as opposed to elected.
Yeah, although they might want to take the elective route. I would say, if you're asking for practical advice, I would say be curious. You know, get yourself positioned so that you are, as Carl said, that good communicator. If you are a good communicator and are able and understand these things, you will take a big role in the commission. You may take a role before the legislature in relying on you to explain things. So be curious and take things on, volunteer for things. I think that also is something. And I will say, participate in NRRI. That's a really good place to learn what's going on elsewhere. As I said, in your state, if you are the person who understands an issue, can communicate an issue, understand how it is being dealt with elsewhere, you will be invaluable and you will be put out there for others to see. And I think that's a good path then, as they look for people, trusted people with good judgment to be on commissions, that they'll come looking your way.
Well, thank you, Diane. This has been a great hour spent together, and I hope everybody has learned more about the process of regulation and certainly the role of staff and commissioners in that process. Next week, we're going to have former Commissioner Sudeen Kelly talk about jurisdictional issues associated with regulation. It's been very important in the past, and it will continue to be important in the future in terms of defining what the role of state commissions is. You can find our these lectures on our YouTube station, which is on the screen right now, and please send any feedback that you have to us at rti@nrri.org. I wish you all well. I wish you all good health, and please be safe. And we will see you next week. Have a good week.